Assalamualaikum warahmatullahi wabarakatuh. Before I start my report or discussion, allow me to introduce myself. I am Siti Jehan Gascon Cadante, and I will be discussing provisions applicable only to pledge, particularly Articles 2093 up to Article 2109. And the remaining articles for these provisions will be discussed later by my co-reporter, Ms. Bakarat. Transfer of possession essential in pledge, the Article 2093. It states that in addition to the requisites prescribed in Article 2085, it is necessary in order to constitute the contract of pledge that the thing pledged be placed in the possession of the creditor or of a third person by common agreement. So, the first reporter, already discussed what is the requisites prescribed in Article 2085, and in addition to the requisites provided in that article, para maging valid yung contract of pledge, the thing pledged must be placed in possession, must be transferred in possession of the creditor or the pledgee or of a third person by common agreement. A pledge is a real contract which requires delivery for its perfection. So that's the reason why kailangan ng transfer of possession, essential yung transfer ng possession para maging valid yung isang contract because it is a real contract, and a real contract requires delivery para maging perfect ito. So, validity of the pledge, transfer of possession is essential to the validity of the pledge. And this transfer of possession may either be constructive or actual delivery, because there is two types of delivery, hindi ba? Yung actual delivery or constructive or symbolic delivery. So, yung kind of delivery of the thing pledged depends on the nature of the thing pledged, because there are things or properties pledged na kailangan yung actual possession talaga or yung actual delivery, at yung mga iba naman, constructive lang ay pwede na. So, for the transfer of actual possession, the delivery of possession means actual possession of the property pledged, and a mere symbolic delivery may not be sufficient. So, if you can see, dito sa number 2, required yung actual possession. But it states that the mere symbolic delivery may not be sufficient. Pero sa pang-third na sa pang number 3, pwede raw yung symbolic or constructive delivery. Yung symbolic or constructive delivery, it depends upon the peculiar nature of the thing. Such delivery of the thing pledged may be sufficient to validate a pledge depending upon the peculiar nature of the thing. So, either actual or constructive yung delivery ng thing pledged, it will always depend on the nature of the thing pledged. For example, in this constructive delivery, for instance, goods, yung thing pledged for a particular debt. So, it is not economical, it is not efficient na for instance, yung goods nakalagay siya sa warehouse. It is not economical or efficient na i-transfer yung goods, yung maraming goods na yun sa place ng pledgee or ng creditor. So, yung mere transfer or mere delivery of the keys of the warehouse to the creditor or the pledgee is sufficient enough para masabing may transfer of possession So, that is called constructive delivery. Pwedeng hindi na yung actual mismo na goods na ginawang security or as a pledge sa debt, but the keys to the warehouse kung saan nakastore yung goods ang i-transfer or i-deliver sa pledgee or the creditor. So, this article, yung bottom line, this article states that the transfer of possession is essential to the validity of the pledge. Subject matter of the pledge, Articles 2094 to 2095. So according to Article 2094, all movables which are within commerce may be pledged, provided they are susceptible of possession. And according to, or as stated in Article 2095, incorporeal rights evidenced by negotiable instruments, bills of lading, shares of stock, bonds, warehouse receipts, and other similar documents may also be pledged. The instrument proving the right pledged shall be delivered to the creditor and, if negotiable, must be endorsed. So, in the very nature of things, a pledge is confined and limited to personal property, and it cannot be extended or made apply to real property. So, yung pledge ay for personal property yon. And the movable must be within the commerce of men and capable of possession. And also, as stated earlier sa report ng first reporter, incorporeal rights can also be the subject matter of pledge. Incorporeal rights evidenced by documents, whether negotiable or not, may also be pledged. If negotiable, the document must be endorsed in favor of the creditor. So, like in sales, yung title to goods may be conveyed by either the transfer or negotiation of the document of title. Public instrument necessary to bind a third person. As stated in Article 2096, a pledge shall not take effect against third persons if a description of the thing pledged and the date of the pledge do not appear in a public instrument. So, para maging valid yung isang contract of pledge against third person, it should be or it should appear in a public document or a public instrument. Kasi if it's not appearing in public instrument, then the contract of pledge is not valid against third person but only to the parties sa pledger and pledgee. So, a contract of pledge is not effective against third persons unless, in addition to delivery of the thing pledged, it is embodied in a public instrument. So, ano yung mga contents or ano yung mga nakalagay sa public instrument? Dapat nandoon yung description of the thing pledged and the date of the pledge. And also, the object of the requirement is to forestall fraud, because a debtor may attempt to conceal his property from his creditors when he sees it in danger of execution by simulating a pledge thereof with an accomplice. So, gist ng article na ito is dapat para maging binding, para maging valid or effective against third person, yung contract of pledge, it must be embodied in a public instrument wherein sa public instrument na yun nakalagay or you will find the description of the thing pledged and also the date of the pledge. Alienation of pledger of thing pledged, or alienation by debtor or the owner of the thing pledged of the thing pledged. According to Article 2097, with the consent of the pledgee, the thing pledged may be alienated by the pledger or owner subject to the pledge. The ownership of the thing pledged is transmitted to the vendee or transferee as soon as the pledgee consents to the alienation, but the latter shall continue in possession. So, it means that for pwedeng i-alienate, when you say alienate, pwedeng ibenta ng pledgee, ng pledger, yung thing pledged without restriction sa ibang tao with the consent of the pledgee. So, para ma-alienate ng pledger or ng owner ng thing pledge or yung debtor, yung thing pledged kailangan ng consent ng pledgee. Why? So, because yung pledgee, he has the right of possession against the thing pledged. Tapos, yung pledger, siya yung may siya yung may right of ownership. Though siya yung may right of ownership, kailangan pa rin niya yung consent ng pledgee para ma-alienate yung thing pledged, because yung pledgee may right rin siya or may interest siya over the thing pledged, because the thing pledged is his security against sa debt or sa utang ng pledger. So, kailangan ng consent niya para ma-alienate or mabenta or ma-transfer ng pledger sa ibang tao yung pinledge niya or yung thing pledged. So as soon as the pledgee gives his consent, the ownership of the thing pledged is transferred to the vendee, subject to the rights of the pledgee. So, diba, yung ownership before the alienation of the pledger of the thing pledged, yung ownership ay na kay pledger or kay debtor. But after mag-consent yung pledgee na i-alienate ni pledger yung thing pledged, yung ownership ay matatransfer sa vendee or transferee or sa tao kung saan itinransfer ni pledger yung owner. I mean yung thing pledged. But it is still subject to the rights of the pledgee, namely that the thing sold may be alienated to satisfy the obligation, and also the pledgee must continue in possession during the existence of the pledge. So, kahit na na-transfer yung ownership ng thing pledged sa vendee or transferee, the possession still yung possession ng thing pledge ay na kay pledgee pa rin. So, it means subject to contract of pledge pa rin yung thing pledged, and pwedeng i-alienate ni pledgee yung thing pledged if hindi mabayaran ni debtor yung utang niya. If debtor defaults, pwedeng i-alienate ni pledgee yung thing pledged kahit yung ownership na ng thing pledged is iba na, hindi na si debtor kasi na-transfer na sa iba. But still, since the alienation by pledger of the thing pledged is still subject to the rights of the pledgee, then si pledgee may right siya to alienate the thing pledged to satisfy the obligation. Like, if nag-defaulted si debtor at hindi nabayaran yung utang niya kay pledgee, then pledgee can use the proceeds from the thing pledged kapag naibenta ito sa public auction, kasi or it is needed that yung thing pledged, if yung debtor nag-default, that the thing pledged must be sold in a public auction or public sale, at yung proceeds nyon ang gagamitin para pambayad sa utang ni pledger. So, para ma-alienate ni pledger yung thing pledged, kailangan niya ng consent ni pledgee. Right of pledgee to retain thing pledged, or right of the creditor to retain thing pledged. According to Article 2098, the contract of pledge gives a right to the creditor to retain the thing in his possession or in that of a third person to whom it has been delivered until the debt is paid. So, si pledgee or si creditor, security niya yung thing pledged. Security niya yon sa utang ni debtor. So, he has the right to retain the thing in his possession until the debt is paid by the debtor. So, the debtor cannot demand its return or cannot demand the return of the thing pledged until the debt secured by it is paid. So, hanggat hindi pa nababayaran ng buo ni debtor yung utang niya, he cannot demand the return of the thing pledged. And the pledgee or the creditor retains the right of possession of the thing pledged. But there's restriction. the right of retention is limited only to the fulfillment of the principal obligation for which the pledge was created. So it means that if there are subsequent debts na ni debtor kay creditor, hindi mag-a-apply yung thing pledged, yung original thing pledged doon sa subsequent obligation. For instance, si A may utang siya kay C. Si A may utang siya kay B na 10,000. As a security, si A pinledge na yung ring niya kay creditor, kay B. Later, si A nangutang again ng 4,000 kay B. So, B or the creditor has a right to retain the ring until the 10,000 pesos is paid. But he cannot retain the thing until he has been paid the remaining debt of 4,000. Kasi, the creditor's right or B's right of retention is limited only to the payment of the 10,000 for which the ring was given in pledge. Note that in the old civil code, the creditor is granted the right to retain the property pledged as security for any other obligation of the debtor. So, sa example natin, pwedeng i-retain ni creditor or ni B yung retention until hindi pa nakakabayad pwedeng i-retain ni creditor or ni B yung thing pledged until hindi pa nababayaran ni debtor or ni A yung 4,000 na inutang niya again. That is under the civil code, but this provision has been eliminated. So, hindi na to applicable ngayon. Obligation of pledgee or the creditor to take due care of thing pledged. As stated in Article 2099, the creditor shall take care of the thing pledged with the diligence of a good father of a family. He has a right to reimbursement of the expenses made for its preservation and is liable for its loss or deterioration in conformity with the provisions of this code. Yung creditor or yung pledgee, since he has the possession of the thing pledged, he has the obligation to take care of the thing pledged with the diligence of a good father of a family, because upon fulfillment of the principal obligation, the pledgee must return the thing pledged. So, kailangan niyang ibalik yung thing pledged kay debtor. So, while it is in his possession, he must take care of the thing pledged. However, he is entitled to reimbursement for any expenses he had incurred for the preservation of that thing pledged. But if due to his or due to the reason of fraud or to his negligence, delay, or violation of the terms of the contract, and there is a loss or deterioration sa thing pledged, the creditor or the pledgee will be liable for this loss or deterioration. So, kailangan niyang magbayad sa loss or deterioration ng thing pledged. But if the loss or deterioration is due to fortuitous event, then the pledgee cannot be held responsible. So, dito sa in this article, it says that yung creditor, kailangan niyang pangalagaan yung thing pledged with the diligence of a good father of a family, and marireimburse siya for any expenses he had made for the preservation of the thing pledged, and if due to his fault or negligence, due to fraud, delay, or violation of the terms of contract, he will be liable for any loss or deterioration of the thing pledged. But if it is due to fortuitous event, then the loss or deterioration is not liable, or the pledgee cannot be held responsible. Moving on to the obligation of the pledgee not to deposit thing pledged with another. According to Article 20 to 100, the pledgee cannot deposit the thing pledged with a third person unless there is a stipulation authorizing him to do so. While the pledgee is entitled to retain the possession of the thing pledged until the debt is paid, hindi siya allowed to or hindi siya authorized to transfer the possession of the thing pledged to another person or to a third party unless may stipulation that is authorizing him to do so. So general rule, yung pledgee, he cannot deposit the thing pledged or he cannot transfer the possession of the thing pledged to a third person. Exception, there is a stipulation authorizing him to do so. Still under Article 2100, the responsibility of pledgee for acts of his employees or agents. The pledgee is responsible for the acts of his agents or employees with respect to the thing pledged. So, it is in legal effect or in legal terms, yung acts ng employees or agents ng pledgee is deemed his. So yung pledgee is responsible for the acts of his agents or employees. If because of his employees or agents there is a loss or deterioration with regards to the thing pledged, then the pledgee will be made liable if it is due to his employees or agents' faults or negligence or like fraud, because it is the acts of his employers or agents are deemed his own acts. Responsibility of the pledgee for flaws of the thing pledged. So under Article 2101, the pledger has the same responsibility as a bailor in comodatum in the case under Article 1951. So this was already maybe discussed by other reporters, but let's still know what is under Article 1951 so we can understand this article. So under Article 1951, the pledger or the bailor who, knowing the flaws of the thing loaned, does not advise the pledgee or the bailee of the same, shall be liable to the latter for the damages which he may suffer by reason thereof. So, if alam ng pledgee yung flaws, ng pledger yung flaws, or there are flaws or defect in the thing loaned or pledged, then at hindi niya sinabi yon sa pledgee or sa creditor, then yung pledger will be liable for any damages na masasuffer ni pledgee or ni creditor. So here are the requisites para maging liable si pledger to pay damages for known hidden flaws. So to pay damages kay creditor or kay pledgee. First, there is a flaw or defect in the thing pledged, and the flaw or defect is hidden. May flaw or defect in thing pledged at hindi to sinabi ng pledger. The pledger is aware thereof, but he does not advise the pledgee of the same, and the pledgee suffers damages by reason of said flaw or defect. Kung may flaw or defect sa thing pledged at itinago ito ni pledger kahit alam niya at hindi niya sinabi kay pledgee, then pledgee suffers damages by reason of the said flaw or defect, then the pledger is liable to pay damages to pledgee. Right of pledgee to compensate earnings of the pledge with debt. So this is under Article 2102. Under Article 2102, The pledgee has no right to use the thing pledged or appropriate the fruits thereof without the authority of the owner. So, kailangan ng authority ni pledgor bago magamit ni pledgee or ni creditor yung thing pledged or bago niya i-appropriate yung fruits nito. But the pledgee can apply the fruits, income, dividends, or interest earned or produced by the thing pledged to the payment of interest, if any, and thereafter to the principal credit. So unless there is a stipulation to the contrary, the interest and earnings of the right pledged, and in case of animals, their offsprings are included in the pledge. So to better understand this provision, let me give an example. Let's say si debtor, umutang siya kay creditor ng 1,000 pesos. At yung utang nito ay may 12% interest, which is payable 6 months after the execution of the contract. At tapos, si debtor, he gave a certificate of stock as a security sa utang niya kay creditor. So, if within the time na hindi pa nababayaran yung utang, and the stocks, yung security, yung binigay na security, or yung pinledge na stock ni debtor kay creditor earns dividends, then these dividends shall also be subject to the pledge if there is no stipulation to the contrary. So si creditor, pwede niyang i-apply yung dividends na ito sa interest, yung 12% interest owing him after 6 months. Yung dividends, pwedeng i-apply or pwedeng gawing pambayad ni creditor sa interest ng utang ni debtor. And if none is owing him or in so far as the dividends may exceed the interest due, C shall credit it to the principal of 1,000 when it matures. So, if yung dividend na nakuha o na-earn ng stocks na security ni debtor ay sobra sa interest na babayaran, so yung sobra, yung excess, pwedeng i-credit or i-deduct ni creditor sa principal na 1,000 pag ito'y nag-mature na. So, yung pledgee can apply the fruits or income, dividends or interest earned or produced by the thing pledged to the payment of interest and thereafter to the principal of his credit. Right of pledgee against third person. As stated in Article 2103, unless the thing pledged is expropriated, the debtor continues to be the owner thereof. Nevertheless, the creditor may bring the actions which pertain to the owner of the thing pledged in order to recover it from or defend it against a third person. So, yung debtor or yung pledger, he will continue to be the owner of the thing pledged unless yung thing pledge is na-expropriate. When you say expropriate, diba may tatlong inherent powers ang state. Yung taxation or yung power to tax, police power, and also yung eminent domain. Yung eminent domain yan yung power ng government to take private property for public use with just compensation. So that is what we call expropriation. So unless the thing is expropriated, yung debtor will continue to be the owner of the thing pledged. Nevertheless, if there are like threats against third persons sa thing pledged, the creditor or the pledgee may bring actions para maprotektahan yung thing pledged or to recover it or defend it against third person. Kasi, hindi ba, according to 2099, the creditor to whom the property pledged has been delivered is obliged to take care of it with the diligence of a good father of a family. So, he is authorized to bring actions na parang siya talaga ang may-ari or he has the ownership of the thing pledged in order to recover it or defend it against the claims of third person. So, pwede niyang, so dapat pangalagaan niya ng mabuti yung thing pledged. He can do or he can bring actions na parang siya talaga yung may-ari ng thing pledged para maprotektahan ito or to recover it against third person. And for this to be valid naman, hindi ba't para maging binding or para maging effective or valid against third person, yung contract of pledge, dapat it appears in public instrument. So the right of a pledge, the right of a pledgee is a real right enforceable against third person, but it is necessary that the contract of pledge be embodied in a public instrument. And kung saan nakalagay yung description of the thing pledged and the date of the pledging. So, just lang ng article na ito is the debtor continues to be the owner of the thing pledged. Kahit anong mangyari, yung debtor or yung pledger ang may ownership ng thing pledged unless it is expropriated. Obligation of the pledgee not to use the thing pledged. This is under Article 2104. The creditor cannot use the thing pledged without the authority of the owner, and if he should do so or should misuse the thing in any other way. So para magamit ni creditor yung thing pledged, kailangan niya ng authority ng owner. So without the authority of the owner or the pledger or the debtor, then the creditor cannot use the thing pledged. Kasi si pledgee or yung creditor, although he has the possession of the thing pledged, he does not have the usufruct or the right to use such thing. Kasi the ownership of the thing lies on the pledger or the debtor. So kailangan niya ng authority ng debtor or ng pledger para magamit niya yung thing pledged. It is because of the reason that the thing pledged or only the possession of the thing pledged is transmitted to the pledgee and not the ownership. Yung possession lang ang meron sa pledgee or ni creditor, hindi yung ownership. So he cannot use it. He does not have the usufruct or the right to use the thing pledged. Right of pledger to ask that thing pledged be deposited. This is under Article 2104. According to Article 2104, still under Article 2104, same with the previous slide. In the following cases, the owner may ask that the thing pledged be deposited judicially or extrajudicially. So these are the requisites para, or these are the things na dapat present para for the owner or the pledger to ask that the thing pledged be deposited to other people or to a third person. So here are the reasons. If the creditor uses the thing without authority, if he misuses the thing in any other way, or if the thing is in danger of being lost or impaired because of the negligence or willful act of the pledgee. So, since dito sa 1 and 2, the creditor uses the thing without authority and he misuses it, then he will break the trust given to him by the pledger, and the pledger may ask the thing be deposited or be transferred to other person or to third persons. And also, if because of the negligence or willful act of the pledger or the creditor, and yung pledger and the thing pledged is in danger of being lost or impaired, pwedeng i-transfer ni pledger or ni debtor sa third person, sa ibang tao, yung possession ng ng thing pledged para mas mapangalagaan ito sa kamay ng third person na iyon or other person na iyon. Right of debtor to demand return of thing pledged. Article 2105. The debtor cannot ask for the return of the thing pledged against the will of his creditor unless and until he has paid the debt and its interest with expenses in a proper case. So, ito similar to sa Sa Article 20098, the right of the pledgee to retain thing pledged. So, si debtor, he cannot ask for the return of the thing pledged unless he has paid the debt and its interest, and also na-reimburse si pledgee sa mga expenses niya para sa preservation ng thing pledged. The thing pledged is a security of the debt of the creditor or the pledgee for the fulfillment of the debtor's obligation. Hence, si debtor, he cannot ask for the return of this thing pledged until said obligation is fully paid, including yung mga interest at yung mga expenses incurred for its preservation. But there is an exemption to this rule. The pledger or the debtor is allowed to substitute the thing pledged, which is in danger of destruction or impairment, with another thing of the same kind and quality. So this will be further elaborated sa Article 2107. So we will elaborate it on that. But kapag yung thing pledge is in danger of destruction or impairment, without the fault, walang kasalanan, si pledgee, he is in good faith, then the debtor can hindi naman mag-demand ng return, but he can substitute or he can pwede niyang palitan yung thing pledge, but it should be of the same kind and quality of the original thing that was pledged. Right of pledger to ask for deposit of the thing pledged. This is under Article 2106. If through the negligence or willful act of the pledgee, the thing pledged is in danger of being lost or impaired, the pledger may require that it be deposited with a third person. So, we have discussed this earlier doon sa right of pledger to ask that thing pledged be deposited, yung pang-third na case for the thing to be deposited judicially or extrajudicially. So, di ba nga, si pledgee, he has the right to, or he has the duty to preserve the thing pledged with the diligence of a good father of a family. So, if the thing pledged is exposed to loss or impairment because of his negligence or because of his willful act, then the pledger or the debtor may demand that it be deposited with a third person. Pwede mag-demand si pledger na i-transfer sa third person or sa ibang tao yung thing pledged. The pledger may also require such deposit should the pledgee use the thing without authority or misuse it in any other way. The right of pledgers to substitute thing pledged. This is under Article 2107. It states that if there are reasonable grounds to fear the destruction or impairment of the thing pledged without the fault of the pledgee, the pledger may demand the return of the thing upon offering another thing in pledge, provided the latter is of the same kind as the former and not of inferior quality, and without prejudice to the right of the pledgee under the provisions of the following article. The pledgee is bound to advise the pledger without delay of any danger to the thing pledged. So, ito yung sinasabi ko kanina doon sa right of the debtor to demand return of the thing pledged. Diba? The debtor cannot demand the return of the thing pledged until the obligation is fully paid, including the interest and also the expenses incurred by the preservation, or in expenses incurred for its preservation. But there is an exception to that rule, and this is the exception. These are the requisites for the pledger to demand the return of the thing pledged upon offering another thing in pledge. First, the pledger has reasonable grounds to fear the destruction or impairment of the thing pledged, and there is no fault in the part of the pledgee, so the pledgee is in good faith. The destruction or impairment of the thing pledged is not due to his fault or due to his negligence or due to the pledgee's willful act. And also the pledger is offering in place of the thing another thing in pledge which is of the same kind and quality as the former. Dapat same kind sila and same quality yung ipapalit sa original na pledge. The pledgee does not choose to exercise his right to cause the thing pledged to be sold at a public auction. So, meron kasing dalawang remedies na granted when there is a reasonable ground to fear the destruction or impairment of the thing pledged. These remedies pertain to the pledger. May remedies para kay pledger at may remedies rin kay pledgee. So, si pledgee, itong remedy ni pledger, this will only be followed if si pledgee hindi niya in-exercise yung right niya to cause the thing pledged to be sold at a public auction. So, kung hindi pinili ni pledgee na ibenta na lang yung thing pledged sa public auction, then yung right ni pledger to substitute the thing pledged ang masusunod. So, this fourth requisite will be discussed on the following slides, Article 2108. Here, the right of pledgee to cause sale of thing pledged. If without the fault of the pledgee, there is a danger of destruction, impairment, or diminution in value of the thing pledged, he may cause the same to be sold at a public sale. The proceeds of the auction shall be security for the principal obligation in the same manner as the thing originally pledged. So, yung right ni pledgee na pwede niyang ibenta sa public auction yung thing pledged is superior kesa sa right ni pledger, because the law says that the pledger is given the right without prejudice to the right of the pledgee. So, mas superior yung mga rights ni pledgee. So, kailangan niya, if there is a danger of destruction, impairment, or diminution in the value of the thing pledged, and di ba dalawa yung remedies, yung kay pledger at yung kay pledgee, if both parties wants to exercise their right, then yung right ni pledgee ang masusunod. Yung right ni pledgee na ibenta sa public auction or public sale, yung thing pledged ang masusunod. Kasi mas superior yung right niya kesa kay pledger, sa right ni pledger. So if the pledgee does not or will not execute his right to sell the thing pledged at the public auction, then yung right ni pledger to substitute the thing pledged ang masusunod. Iyon ang mafa-follow. And yung dapat note that the sale must be at a public auction or a public sale. And yung proceeds na makukuha sa auction na yun ang magsisilbing security or the new security. The pledgee or the creditor shall keep the proceeds of the sale as a security for the fulfillment of the principal obligation. So, si pledgee yung proceeds na makukuha niya sa auction, he will keep that and keep that as a security para sa principal obligation until the obligation has been fully paid by the debtor. So that's all for my report. I hope you have learned about my you have learned something about my report. If you have any questions or clarifications, feel free to contact me anytime. Thank you.